About to go live. It says we're live. Okay. Hi. I'm about to start this in just a few minutes. If you've just tuned in, you are watching Taking It Black, and we're trying to make sure that the computer sits properly. So, hi. Yes, that'll work. I look like a little chipmunk, but yeah, it'll work. Uh, it's not about what I look like, is it? No, it's about what we're talking about. So let me get my paperwork together here as you watch me prepare to do Taking It Black here on 987 KISS. And you know where we are on the web, and tell mom and them, find some friends and family to join us, because it's a great community program, and it's a great community program because of the people who I have had so many people contact me saying, where are you? Well, this is where we are. And we're on Heaven 610 WAGG, and then the new FM 100 on Sunday. So on Sundays, you can find us on the new 100 Heaven WAGG, I should say. And that's the FM station 100. And then on Saturdays, we're on, 6 o'clock on Sundays, and then 5 o'clock on Saturdays. So right now, we're going to get started. Such a big week to discuss news. I do know where to start. We've got to start with the update for the Chauvin trial. And if you've been paying attention to the trial, we're at the very end of the trial, where the defense has rested its case, not before presenting to the jury some, I think, ridiculous defenses. But they have to do something. Derek Chauvin decided that he would not testify. Most defendants don't, because they would get just pulverized on the stand if they did testify. So for that reason, no, he decided not to testify. He would be no different. He would be as vulnerable as anyone else. So as a result, they've rested their case, and they're going to be working with the looking at doing closing arguments next week. But I want to talk with you from a legal perspective here, just sharing with you some of the things that are a part of what the jury will be considering. The latest defense, and they've been presenting some pretty ridiculous defenses here. I think this last one is the worst of all. It came when a defense expert, a forensic pathologist, Dr. David Flower, suggested that carbon monoxide from the squad car's exhaust pipe was possibly a contributing factor to Floyd's death. Now, why is that ridiculous? Well, it's ridiculous because who put George Floyd under the exhaust pipe? I mean, he didn't just say, oh, gee, there's an exhaust pipe. Let me lay here so it would be a comfortable place for the officer, Chauvin, to put his knee on my neck and I can inhale fumes as I go out. Of course not. That is ridiculous. They put him there, and they're saying that that's probably how he died, not by way of of my knee or his knee being placed on his neck, choking him out over 9 minutes. The prosecutors said that the lab tests were discovered, that there were lab tests discovered when the medical examiner who conducted Floyd's autopsy heard the testimony and said, wait a minute, they're trying to say that the exhaust did this. I have tests that will show otherwise. Okay, putting my lawyer hat on, you can't do that. So the defense attorney, rightfully so, said, wait a minute, file, that's not going to work. They knew, we told them what our defenses were. We told them who our experts were going to be. They were well aware prior to trial of what this testimony would be. It's no different than what we told them it would be. So to tell us now in front of a jury that they have tests that will show it that there was no elevated or dangerously elevated carbon monoxide in his system would not be fair. And here's why. Because it would make them look like what they are in front of the jury. It would make them look as though they're just making stuff up. Well, if the defense team had known that there were tests that showed that there was very low levels of carbon monoxide in George Floyd's system, they would have presented testimony differently, right? It doesn't matter what the facts are. It doesn't matter what's true. This is the defense now. The prosecution is held to what's true. The defense, they're not supposed to lie, but the defense lawyers are really supposed to they're working to get their client off, not at finding what the facts are. So in this case, the prosecution is held to a higher standard. They are required to let the defendant know what tests they have, what evidence they have as they prepare their cases. And in this case, they didn't focus on carbon monoxide poisoning. And it's a long trial. It's a big trial. They did a great job. The prosecution did a great job of putting together their case. You're not going to be perfect. This is something that they missed, and they missed it. If you have to take off on the prosecution, you take points off on this because, yeah, they did miss it. The defense argued that the state had knowledge about Fowler's testimony since February and could have investigated the carbon monoxide test. And again, they didn't need to investigate it. They already had tests. They just didn't say we have these tests, and they didn't present them or give them to the defense. The defense argued that the introduction of the evidence now would be prejudicial, and it would, because once the prosecution came back and said, don't believe that, that's a bunch of junk science, because this is what the autopsy proved. Well, if you didn't show it at the time you put on your case, you're not going to be able to do it in rebuttal. They were allowed to bring a rebuttal witness, but they could not bring any rebuttal evidence that had not already been turned over. And the defendant said that and the defense counsel said that they would move for a mistrial if the judge were going to allow that. And here's the problem: that if the judge had allowed it, and the judge didn't, but had the judge allowed that not only testimony, but the evidence to come in, they would have had an option. They would have been able to file an appeal that would probably have been upheld. So you try to eliminate, when you're in trial, you try to eliminate, if you're defense, you're trying to, you want every opportunity for appeal. And if you are the prosecution, then you want to eliminate any opportunity for the defense to appeal a guilty plea, a guilty verdict. The defense need only present a reasonable doubt. That's all they have to prove, is reasonable doubt. And here's some of their defenses that they looked at. We talked about the carbon monoxide poisoning. There was really none found. The medical examiner said there was really no carbon monoxide to speak of in George Floyd's system. They used the example of a drug overdose as a defense, and they had testimony from physicians saying, or from witnesses saying, he had talked about his drug addiction. He had talked about in the past his challenges in trying to get past his drug addiction. And so as a result, uh, if you would believe that testimony, then you could possibly extrapolate that. I don't know how, but they're hoping that the jury will extrapolate from that he may have been on drugs at the time of the occurrence of the murder, um, and as a result, then you get not guilty, right? If he died because he was going to die anyway, he's on drugs, he was going to die anyway for drug overdose, then what Chauvin did was not a contributing factor or the contributing factor to his death. They also used the examples of pre-existing conditions, that he had heart condition. He had a heart condition, and as a result of that, he had, I think, even down to a pre-existing condition of cholesterol, high cholesterol, just craziness, trying to say that those things were the contributing factors to his death. Now, what the jury will be charged with was to find, if they're going to find that he's guilty, that Chauvin did commit murder, then they're going to have to find beyond a reasonable doubt. They're going to have to find beyond a reasonable doubt. Reasonable is the phrase that we're looking at here. He was under a man's knee for 9 minutes. He was breathing fine before that. You could hear him in distress in the beginning and in the middle of that. And at the end, when he removed his knee from his neck, he was deceased. He was dead. He had expired. And so, is it reasonable to believe that a drug use was the contributing factor that caused Floyd's death? No. I don't think that there's you can say that beyond a reasonable doubt he's guilty, and that, or not guilty, and it's because it's reasonable to believe that drug use in this case at the time of the incident caused his death. There's no evidence to support it other than their suppositions. Is it reasonable to believe that carbon monoxide poisoning was the result of his death? He was there 9 minutes outside under the exhaust. It wasn't up to, the exhaust pipe wasn't over his nose. So there's no way, even just forget what the tests show. It is unreasonable to believe that someone laying down, even right under an exhaust pipe, would die from carbon monoxide poisoning. And the precondition or pre-existing conditions, is it reasonable to believe that a heart attack was on its own, without any contribution to his air being or him being suffocated, that was the contributing factor, that the heart attack was the reason that he died, and not the fact that the heart attack was caused by him not having sufficient air. So I just don't think that any of these defenses are going to be reasonable. All you need, though, is one. All you need, I have to keep saying that, all we need is one, and that doesn't mean that one is going to find that he is going to be found not guilty. What that one will do is hang up the jury, to the extent that if they're hung for several days, then the judge will say that this is a mistrial. The jury is hung, and then they'll have to if they're going to try him again, they'll have to try him again. Perhaps there'll be a plea. What are the possible outcomes of the Chauvin trial? Well, he can be guilty, not guilty, or a hung jury. Well, when you look at this, I want to look at the various opportunities we have for an outcome here. The official instructions presented to the jury before they go into deliberation after the closing line will be, "We await your verdict." They actually have to bring the verdict. The defense will close, the prosecution will close, the judge will have said, the last thing that the judge will say is, "We will await your verdict." It's all going to be on the jurors. And what do they have to decide? They have to decide again whether he's guilty by first degree. I'm sorry. Is he guilty by second degree unintentional murder while committing a felony? So they're going to be instructed that they can find that he could be found guilty of one charge. He could be found, or he could be acquitted of all three charges. Here are the charges that he can be convicted of. Second degree murder, which is unintentional murder while committing a felony. Let's be real clear of what that means. They have to decide that the state has proven beyond a reasonable doubt that Chauvin caused Floyd's death while committing a felony. What was that felony? Well, in this case, it would be third degree assault. So he was committing an assault, third degree assault, whether he was trying to kill him or not. That assault resulted in his death. And because it resulted in his death, that assault would, if left alone, even if he wasn't, even if Floyd had not died, it would have been resulted in substantial bodily harm. And because of that, it is second degree assault. Second degree assault is a felony. He's committing a felony. In the process of committing a felony, someone dies. Second degree murder. Okay. And the next charge is third degree murder. The jurors must consider whether Chauvin committed third degree murder by committing an act that was imminently dangerous to others. That means just what he was doing right then could cause the death right then of others. Well, in this case, George Floyd. And let's see, imminently dangerous to others and evincing a depraved mind. And all that means is evidence. I'm using the actual wording of the code. An act eminently dangerous to others and evincing a depraved mind. And all evincing means is that it exhibited, that his conduct, his actions exhibited a depraved mind without regard for human life. They could find that would be third degree murder. The last charge would be second degree manslaughter. And the jurors must find in this case that Chauvin caused Floyd's death by culpable negligence. And that is, culpable means that you are responsible. Your actions are responsible by culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances causing the death or bodily harm of another. Well, in this case, he consciously took chances. I'm going to put my knee on this person's neck. I'm not doing it to cause his death, but I'm going to take a chance that I can do it and he won't die. Well, you took a chance. He did die. You can find that it's second degree manslaughter. In this case, none of the charges required the jurors to find that Chauvin intended to kill George Floyd. So there's no reason to prove intent. Intent is not an element in any of these charges. The jurors must consider the charges under the legal standard, though, that the legal standard for police use of force, that the police used objectively reasonable force from the perspective of another reasonable officer in that same situation or similar situation. So what we have to look at, the standard that is used to show whether or not he's guilty, you got to consider all of the elements that we discussed earlier. And then you've got to line that up with, irrespective of whether he did these things. Now let's look at what a reasonable officer in a similar situation would do. Would they do something similar? Well, in this case, we have heard testimony from several officers saying, hell no, I wouldn't have done that. Of course not. I wouldn't have put my knee on that. That's not even the way we're trained. So you've got officers who are on the force right now who are saying that's not what they would do. They didn't find it reasonable. So again, you have, in my opinion, the prosecution has proven its case and met the elements there, and has met the standard that he being Chauvin, did not act by the legal standard for police use of force, which is he was not objectively reasonable in his actions, because there was evidence and nothing to the contrary of these of the testimony that we heard. The defense didn't bring anybody in to say, oh, but I would have done that. I would have put my foot or my knee on this man's neck. We do that all the time. We heard evidence from and testimony from officers saying, no, that's not the way we're trained. No, even his superiors, that's not the way we're trained. That's not what we do. And no, that is not reasonable. The defense would have to have shown someone coming in, some evidence coming in somewhere, whether it's in a book where the judge takes judicial notice of, something to prove or to exhibit that what he did could be considered reasonable. They didn't do that. So I think that the prosecution has met the standard that, or shown that his actions, his being Chauvin, did not meet the legal standard for police use of force. However, I must say again, it only takes how many? One. It only takes one juror to say, nah, I don't see it. I think that we need to let him go. I think we need to let him go. And everyone else can say, no, we believe he's guilty. And they can be ready on day one to say he's guilty. All we need is one to say no. And then at that point, we have a hung jury and it starts all over again. Unless, of course, they plead, they being Chauvin, his team, plea him, or the defense decides not to pursue any further legal action against him. I want to look at another case regarding a police shooting of an unarmed Black man. And an unarmed Black man was killed last week. Daunte Wright, he was killed by an officer who mistook her taser for her weapon. Her taser for her weapon. Now, the taser is bright yellow with a black handle. Doesn't even look like a Glock. She has a Glock. I have a Glock. There's no way you can look at a Glock and look at a taser and think that these two are the same. And it wasn't a split second situation either. She had plenty of time to discern whether or not the weapon in her hand or the object in her hand was a taser or her weapon. Let me just get into it. 20-year-old Daunte Wright is dead because of a 28-year veteran of the police force. That's important because I'm getting ready to bring on an expert here. Well, I'm going to say, I'm going to consider you an expert. I'm going to bring on a 35-year veteran of law enforcement to talk with us about it. So I'm going to give you my perspective here, and then we're going to get some information from someone who has done this for 35 years, worked as in law enforcement for 35 years. But we've got this 20-year-old, I say kid, younger than all of my children, Daunte Wright. He's dead because of a 28-year veteran, because a 28-year veteran of the police force felt the need to use an aggravated force at a stop where the individual she stopped, the 20-year-old, decided to flee from a misdemeanor. So this isn't a fleeing felon, and we're going to hear from our expert here to talk to us about use of force in that regard when you have someone who is trying to flee. We understood in law school you could use lethal force if you have a fleeing felon. That wasn't the issue here. This guy was fleeing from a misdemeanor. And then once she decided that she wanted to aggravate or the force that she's using, she decided she wanted to use a taser. In her mind, she's saying, I'm going to use a taser, or so she wants us to believe. And she very well may have. She very well may have. She just may be incompetent and not evil. Either way, a boy's dead and she should not be on the street. So she confused a Glock for a taser. The stop was for a minor offense. The fact that the young man's tag did not have the little tabs that go on the back of the license plate, the color tabs generally change each year. Well, his was out of date. And because he didn't have the right tag, she stopped him, or tab on his tag, she stopped him. Now, as a result of COVID, Minnesota, where this happened, is behind in mailing out those tabs. So we don't know whether that tag registration had been delayed because of COVID. All we know is the young man did not have it. So even if he were guilty of it, of not having a tab on there, it could be that he's paid for it, but the city itself has not, or the county hadn't sent it out because their people are working from home and not available in the office to send it out. Again, as a result of COVID, Mr. Wright would probably have not been held in custody for this offense. Why? Because it's a misdemeanor. He was on a misdemeanor warrant for, I think, not having his license for his gun. And it was a non-violent warrant. As a result, I know in Jefferson County, individuals are allowed to sign, or they're given a citation and they're allowed to sign recognizance bonds. So it's not like you're going to have him tucked away, throw him in jail, and he's going to be incarcerated and away from everybody that you're protecting him from everyone else because he's such a violent offender. That's not what this is. We're not looking at a violent offender here. They had his information. They knew they could, if he got away, they could go and pick him up. That they were aware of that. They could go and pick him up. They knew who he was. And then on top of all of that, I have to go back. She confused a yellow taser with a black Glock. Totally different. The weight of those two weapons are completely different. The position on the body, as you're going to hear from our expert here, are different. So, I'm confused. So I'm going to turn here to to Mr. Wilson Held, 35-year veteran of law enforcement. What should this officer have been trained on regarding the use of a taser?
I can't say it was training. How you doing?
I'm doing well, thank you. You can see I'm a little frustrated.
I see you a little frustrated. I'm a little frustrated as well, just the same.
Since we're not actually on radio, you're actually being filmed. So we gotta. This was on the web.
At least they thought. I guess they thought they include us all. Then
you don't have a radio face. We wanted to make sure they see your face.
I feel blessed.
Yes.
I can't say that it was particular training, and she referred to, well, let's go back to the stop itself. I can't see where she could actually, there were 3 of them on the stop at the time that they had this young man. He had his hands behind him prior to getting the cuffs placed on him. And he decided to snatch his hand and swiftly get into the vehicle. Now, be mindful that there are 3 officers there, herself and 2 other males. And I can't articulate you drawing pepper spray, taser, or your firearm to subdue this young man. He only weighed maybe 110 pounds at the most. They had him. Yes. They had him outweighed.
And outmanned, as you said, 3.
And I just wonder what goes on with this police chief and how he's teaching them to use this X26 that they have. It's called a taser. But I'm concerned with what else are they doing with use of force up there. If you have 3 people, that's 6 arms, and you can't detain a 110-pound person, young kid, or either talk to him in such a manner that it would even that you could de-escalate the situation to where he would say, okay, I'm going to go along with this.
That's a great point.
You can articulate on paper, when I read the paper anyway, that you had to go to this extreme. Now, had it been a female, would you have taken the same precautionary methods that you use right here? And had it been a white female, would it have been the same as it had been on a black female? So I extend that part, but we are dealing with the situation at hand. But again, I can't see how 3 officers can articulate using any kind of weapon whatsoever to get this guy just in handcuffs. The young man decided he wanted to jump inside the vehicle. He gets inside the vehicle at any cost. He was not even close to the female herself. There was another black male that was in front of her, the one that he actually pushed off and got away from. And she decided to holler, taser, 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 and clear everybody from even approaching the young man.
Stop. Because, see, you're saying something you assume that we understand, and that is when she said taser, 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 that was to give everyone warning, and they do what?
They actually move away from the subject that's about to be tased or the one that's causing the haste.
So if she had not said that, then
they would continue.
They could have continued
to apprehend the suspect that was there at hand. But because she didn't want to do this, and this is where people are always going to their belt. Yes, that's what it is. They're purely lazy.
Yeah.
Or they're scared to get in a fight or a scuffle, or scared to get on the ground.
You've always said that too many officers
they are.
Yeah.
Some of them have never been. And we have some good officers. 90% of them are. My scale is getting lower, but 90% of them are. But we have some officers that's scared to get on confrontation, or they just want to look good in their uniforms to go in a restaurant or show up at their child's football games and get praises. But incidents like this have been occurring for many years. Then it's not new. They're just being recorded more. That's all that it is.
Yeah.
It's no different. But the subject that when the subject got in the car, she decided to yell taser 3 times. That's to move the officers away. That if they did have hands on this young man, they stopped doing what they're doing because they know what it feels like to get those electric probes and 1,200 volts sent through them. You have to acquire that when you're going through taser training. So once she did that, and she said that she thought she had her taser. Well, let's look at that. A taser is a bright yellow color, pretty much, unless you painted it or did something to it, and you're not supposed to be altering taser because the equipment doesn't belong to you. It has a different handle on the stock end of it where you hold it. So it doesn't go into your whole hand like a normal weapon would. The weight ratio is nowhere close to the weight of where you would have a magazine in a Glock or any other weapon of choice that has a firearm. It is nowhere close to the weight ratio of a taser. So those 3 things should have clicked in her mind. The other part is that she's not close to the subject. She's at least 4 feet because when he pushed off, she stepped back and the other officer was trying to detain him. She just decided I'm not finna fool with this. And she might have called him a couple of words in her subconscious mind. I'm just going to go ahead and and fire this shot off at him.
Yeah.
Be it taser.
How dare you try and pull away
yeah.
from me? She was mad.
Yeah, she was mad.
She was allowing
Furious.
her emotion to guide her decision.
That's exactly, and that's most of where this is. Their feelings, emotions, or you're not gonna. They have this superior
Yeah.
thing
I'm in
about
charge
this
here.
uniform.
How
Yeah,
dare
you're gonna
you?
respect what I'm doing here.
Yeah.
And it's so much of that that goes on today. But nobody, and it's just like children in high school and wherever else. The first thing they do is go to a weapon. They're scared to get knocked out.
And then we wonder why our kids go directly for a weapon when they enter into an altercation with someone. It's like the whole society is saying, I'm not going to sit here and go through the process. I'll just kill you and we'll just be through.
That's exactly what they do.
We'll just be through.
And we'll be through with it. I don't have the answer to this no more. But like I said, before they had intermediate weapon, and there's a scale for weapons. Even when you first get there, your approach from when you first get out of the car, your appearance is just a tactic that things need to change. When people see you just get out of that patrol car, your car just showing up there, it's a force continuum that when you get out of that car, they see the presence there. The presence itself is a force, all the way up to deadly weapon. Now, be mindful that in a case, I think it was 18 months ago, there was a case that a subject, they used a taser, and tasers don't affect everybody, just like the pepper spray don't affect everybody.
Okay.
And there's quite a few that were in our class that's not affected.
I didn't realize that.
It doesn't. So the subject grabbed the taser in the case that I'm talking about. They grabbed the taser. Well, once the subject grabbed the taser, the officer felt that the need to shoot him because he felt like he was being used as a deadly weapon. The taser was being used. But if the taser is being used as a deadly weapon on the officer, is it not a deadly weapon on the subject?
Yes, I remember. Yes, I remember that case now.
This is extraordinary for this Brooklyn Center police officer, 26 years vet.
28-year vet.
28-year vet.
Of the police
She has
force.
no discern. That's what you were speaking about.
And she was a training officer.
Well,
as a matter of fact, I think that one of the officers with her, they were supposed to be training. She actually trained officers.
Well, the first part about actually training officers is that you need to follow in order for you to lead. You can't just jump up and say, I want to be a trainer because of the way that people taught it a long time ago. And I see where you were speaking about Mr. Wright. It's a child, and it's somebody's child. For them to immediately go to a force that's next to deadly force, and that's next to deadly force.
The taser is. Okay.
The taser is. And on the continuum, it's next to deadly force. And for you to go that extreme for a tag, and they spoke about him actually having a warrant. And
he had a warrant for not having his gun permit.
Well, still, that's a warrant from a case. If it was that important, the U.S. Marshals would have found him by now.
Yes, indeed.
Or they would have went out to his house and checked up with all of this would have taken place. So it wasn't that important for a misdemeanor for you, nor did he have a weapon at the time that this occurred. He was not carrying a weapon. Only thing he had was his mouth. And if he said something, that made, like you said, they get their feelings involved. They don't want their feelings hurt. And you will respect me because and you go into these minority communities and create this rap that where people are today. And the people that are actually in these communities, they're actually trying to make a way or trying to come out of this poverty level. I'm not understanding why are we going and executing warrants or stopping people for tags or anything else over COVID and all that's going on through the nation today. Everybody's delayed. The situation should be delayed. The tags, the license, the insurance, everything's delayed because people can't get to work to update this information on the computer. So whoever the police chief or whoever is acknowledged, I don't even know why they're enforcing these rules right now because it's just causing more havoc on the people that are trying to make it, that's already in these minority communities to start.
And what I don't understand is when I see them, we talk about over policing certain areas. Whenever you hear or whenever I've heard about these instances where police have shot someone who didn't have a gun, but I would say 99% of them were individuals like this young man, or the individuals like Philando Castile, or I can name any number of individuals who were shot who were good people. They weren't doing anything that was inherently violent. And what about the individuals who are shooting up our communities on a daily basis? I don't see the police approaching those individuals. How is it that those individuals are never the ones who are stopped, never the ones who they encounter, or if they do, they don't seem to shoot them. And I'm not saying it's done on purpose. Please don't think that I am. I'm just saying it makes you wonder, why is it that the individuals who are the most violent are never really ever caught up in this?
We just had an insurrection. These are people that have automatic weapons that has stormed the Capitol and did all kinds. January 6th, they won't forget. But you have a young man that for attack lost his life. His life was taken because of a tag or a misdemeanor warrant that may have been cleared up, but like I said, the system is delayed. We don't know if it's cleared up or not. Now, there's a case of Torres in the city of Madero where a female, she drew her weapon and mistakenly, and she actually shot the subject, and the court ruled that she was not qualified immunity in the lawsuit over his death.
So they did not give her qualified immunity?
No, they did not. So, and it explained that that was what happened. And what she did was approach, the young man was arrested and placed in the backside of the car. And he laid down and started kicking in the window. Well, she was the closest to the car. So she decided that, hey, he's going to hurt himself. So what I'm going to do is pull my taser out and tase him. Well, she pulled her weapon out instead of the taser and shot him while
so
he's handcuffed
in the back of the car.
Yes. So, and that's where they got like,
again,
how is that
lazy?
It's just
lazy. There was no way that could be considered reasonable. So she was not granted qualified immunity.
No, she was not. But there are several. In fact, there are nine cases that were reported, but only 2 had fatalities in them. And the judge on the 3-panel judge that declared that 2 of those were not declared as having immunity for those issues.
I'm glad you brought us to that point, because I want to talk about another case where qualified immunity is going to come up. And this involves not just, I want you to stay with me on this one, because it involves not just your background as a law enforcement, but also your military background. I'm sure, unless you've been under a rock, you've seen the video or heard the story of the active duty African-American second lieutenant. His name is Caron Nazario. Caron Nazario. He has filed a lawsuit against a Virginia officer who tased him or pepper sprayed him during a routine traffic stop. Again, the man was stopped because they said he didn't have a tag. He had just bought a vehicle, nice vehicle. And he had a tag from the dealership showing that he just bought the vehicle and he had applied for the tag, and it had all of the codes on it. So, there are numbers on there when you've applied for a tag. All of that was on there. So the officers spot him. They don't see a tag. And in all fairness, I'm going to be all fairness. If you're driving behind a vehicle, you look for a tag on the bottom. They're supposed to be lighted up. You don't see one. Maybe they didn't look up in the window to see where the paper tag was, because it's a paper tag. There was no reason for them to put it outside. So he drove to a lighted area. So I would think that they would have probable cause to stop him because the tag was not visible, right? Reasonable. he, after putting the lights on him, he continues to drive for 1 minute, 41 seconds. He drives to a well-lit area. I think it was a gas station, a fuel station. So he pulls up into the service station, and as soon as he does, they pull in behind him, jump out of the car with their weapons drawn, screaming and yelling as though they have been on a high-speed chase for 3 or 4 hours. It is totally, from the beginning, it is unreasonable. He's in military uniform, and as a result of them their stopping him, he was eventually just completely humiliated. There was no reason for this action. The officer was out of control from the moment that he got out of his car. The little guy, the second officer, looked like a little trainee. I don't know if he was, but his little gun was just shaking like Barney Fife as he's standing there, looking at the screaming officer like, why are you doing this? Even when they finally calmed themselves down, because he's the gentleman, lieutenant, second lieutenant is saying, look, can you just calm down? Can we talk? Can you just calm down? But he wouldn't. He just kept screaming. Even at that point, he threatens to end this young man's career if he told anyone. He was not even issued a citation. Why? Because there was no reason to issue a citation. The reason that they stopped him was void. Once they got there, they saw that the man had a tag. There was no reason to give him a citation. Had he not been in a well-lit area, I think the outcome could have been extremely tragic. I think that it would be tragic. The Army lieutenant has filed a $1 million. He asked for at least $1 million in his lawsuit. He is claiming that qualified immunity does not apply to this situation. And as a vet, there are a couple of questions I want you to answer here, because we have about 15 minutes left in this program. With respect to this veteran, as a veteran of the U.S. Army yourself, could Lieutenant Nazario's career have been in jeopardy as a result of what took place that evening when he was stopped?
No. We have soldiers all the time that get stopped. They get stopped on military base, they're even more serious about violations on military base.
Why would they say that?
Well, it was a threat that if he didn't know any better, it's pretty much calling him ignorant in his face more so than anything. But like on a military base, you get stopped for 4 miles over the speed limit. They're very serious about their traffic laws that's on that base. So I'm sure he understands that, and he would not. I don't suspect. I don't know the young man, Lieutenant. You said, what is his name, Lieutenant Nazario? Mm-hmm. He did everything that he could possibly do to de-escalate the situation himself in respect to the officer, and he respected the officer's uniform. He respected the lights that were on the car. He respected it enough that he went to the point to find a safe place to pull over. I've had many people, some of them drove 4 and 5 miles to get off the interstate or off another ramp or turn a corner where they felt safe. And if it suits them to feel safe in that capacity as to him pulling into a well-lit service station for another 40 seconds, I don't see why.
A minute, 40 seconds.
A minute, 40 seconds.
Yeah.
Even if it had been 3 minutes and 40 seconds, I don't see why the officer, Gutierrez and Cocker, would feel that they were being eluded. They called it in as a high traffic stop being eluded. And even so, Joe Gutierrez himself also made the statement to the news media that I figured that he had to be a minority because 80% of them want to drive to a well-lit area anyway.
What?
So that was
I didn't hear that. Who? The officer said that?
The officer that actually told him that he was going to take a ride on the Lightning. He made that comment to him at the back of his truck later on that, 80% of y'all, minority is what he's speaking of, always drive to a lit area. And that's something
Well,
that
maybe
in
he
my
was
mind
mad.
they said that he wanted him to stop
Yeah,
out there
in the
before
dark.
he got in the dark.
Mhm.
That tells me there's no telling what would have happened. He's wearing fatigue, so in dark, you're black
Yeah.
anyway. His skin is dark, he's dark, and I don't mean that dark black as
Yeah.
to his skin, but he's a black male.
Right.
So at any point doing that, it was reason for him to say the magic word, "I felt for my life."
Right.
I thought he had a
could have
weapon.
said that, yes. In
He
the
had all
dark,
these pockets
he
and
could
he
have
kept
said that.
reaching. I didn't know what he was doing.
Yes.
But what saved this young man's life is that the service station was actually there. I do believe that, but that didn't take place. I'm just saying, just speaking as an officer, I've had many people to drive to a well-lit and safe area. If it's safe for me to get out and I don't have to stand out there on the side of the road,
Right.
risking getting hit, because I've had several of my other co-workers that have gotten hit. Some killed, some just drugged down the road. So in a safer environment for me to perform my duty, it's safer for everybody.
You know, I was talking to one of our kids this week, and Bethany reminded me. She said, "You told us if we're driving and it's dark, we're on a very dark road, and the officer gets behind us to put on our flashers." I remember that part. And she said, "And you told us to call the operator and say, I'm being pursued by an officer. I see his lights. Would you please acknowledge that I see his lights? I'm trying to get to a well-lit area." I forgot I told her that.
Right.
But let me ask you, is that reasonable?
That's reasonable. It's not as if they were being stopped. He's being stopped for a tag.
Mm-hmm.
And when he's being stopped, he's not like he's being stopped for speeding. He slows down even from that scenario.
Yeah.
And coasting to this service station. And he should, like I said, he should have been thankful. But once the officer himself, if he was observant like he should have been,
yeah,
and both of them are standing on the same side of a vehicle, which is a hazard because the vehicle is tinted.
Mm-hmm.
They don't know if anybody is getting out on the opposite side or not.
Right.
But the other young man, he really didn't know what he was doing.
He had no idea.
That was his backup.
Yeah.
He's what the officer terrified the subject as well as his partner.
Yes, you could tell he was
shaking,
unnerved.
So had he had his hand on the trigger, as nervous as he was, it doesn't take much for a Glock to go off. It's like 3 pounds of pressure.
Yeah, and they were there in front of. You could see the pumps.
You could see the pumps.
If he had
hit,
he could have blown them all up.
Exactly. But as I say, with the as the officer being observant, even after he sprayed him, he never knew if anybody else was inside the vehicle because there was a dog still in there moving around trying to get out of the pepper spray. He had to warn them and let them know that there was his pet was inside the vehicle. Safety.
He, again, in my opinion, in this situation, the officer had no reason to be in fear of his life when he sprayed that man. And he continued to spray him. So if you are in fear of your life at this point, why would you be spraying him? Just take out your weapon and use it if you are truly in fear of your life. But he wasn't.
If you look at the officer, he's not in fear of his life because he looks down and searches for the pepper spray. He wasn't looking at the guy.
Yeah.
He looks down. If you're taking your eye off of something and you don't know where your materials are on your belt, you're setting yourself up to get hit in the head or face.
Again, incompetence. Total incompetence.
Yes. And even, as far as the officer, he should include the chief of police that's down there as well with the negligence of even having the officers trained correctly. He said that the officers did not owe him any apology. They should not apologize. He didn't do anything wrong.
Who said this?
This is their chief of police.
Okay, so then he should be
so he didn't find it to be anything
terminated
wrong.
as well. And I have to look that up. I know that the officer was terminated. I don't know if the chief of police was terminated.
Well, the chief decided he was not terminated, but he said that no, they didn't feel like they owed the soldier an apology. His attorney got on there and spoke about it this morning, but he said that that's more of a cover-up, like we didn't do anything.
Okay, but let me say this as an individual who is in, at that level in government. if you apologize and you got a $1 million lawsuit out here,
Yes.
then you might as well just write them a check for $1 million. So
Well,
I understand him not
Mhm.
apologizing. I don't understand him saying we don't have anything to apologize for.
Well, is it not contradicting that they fired him?
Yeah. Oh,
So
right.
if they fired him, well, for what reason did you fire him?
Yes.
If it's not saying that
he did
something wrong.
Exactly. and in this case, in this situation, we're going back to, because we only have about less than 10 minutes here. But in this case, it goes back to the issue of qualified immunity.
Correct.
And for all the things we've been discussing here, I don't see how this officer or the department is going to get around this lawsuit, because he can't have qualified immunity for actions that were not reasonable under the circumstances, where a reasonable officer would not have conducted themselves in that way.
Well, in order to qualified immunity doesn't mean that police can go out there and do whatever they want.
No, you have that legal standard.
When you get in a certain situation that it calls for you to make that 1 split second or 2 second
I can understand that.
That's something
different. Yeah.
You're not knowing the totality of the whole circumstance.
Right.
But you have to make a call according to what you see, even if you just popped around the corner and behold somebody.
Even if you're wrong.
Right.
Even if you're wrong. It was a split-second decision.
It's a split-second decision for you just popping around the corner.
I understand.
And somebody may have picked up a weapon that the subject just accidentally had.
Right.
And they accidentally get shot. That's the qualified immunity part. Mm-hmm. Him sitting up here searching for items on his belt, not knowing where it is.
Wait a minute, I'm going to get you. Wait, just let me find this.
Being confrontational with the subject
the whole time.
The whole entire time. And telling him he's going to ride the lightning. I mean, he never approached him and told him what he did or why he was on this high profile stuff.
And that's what I don't understand. That you don't feel that Black men are worthy of an explanation. Even the young man, the 20-year-old, excuse me, sir, do you know why I stopped you? I always hear them say, do you know why I stopped you? They always ask me that. Do you know why I stopped you? They could have said, do you know why we stopped you? Well, you'd had an expired tag. We're going to check for warrant. Well, we found there's an outstanding warrant. This is a misdemeanor warrant. We're going to take you down to the station. What will probably happen, sir, is that they're going to book you, but then you will be able to sign yourself out on your own recognizance. Why can't you just treat him like a human?
But once you find that tag in the back of the window of your observance, it should have just been an apology. There's no probable cause.
Yeah, in that case, you're right.
No probable
there was
cause. You said, sir, I didn't see your tag because all SUVs come tinted on the back end. So I didn't see it because we were in the dark. Right. Now that we're in the light and we up under this service station light out here, I see your tag.
Okay, my bad.
We're good.
Where you stationed?
Right.
Thank you for your service.
And let that be that.
Yeah.
It should not have even gotten to that point.
Yeah.
But it was so much because he was aggravated that the young man continued to drive to that. His feelings and emotions got in it, and that's what brought that to this point right here.
Mm-hmm. I agree. And next week, I want to talk about a young man a 13-year-old. The 13-year-old was killed. He was unarmed, but he was killed. And it was a kind of sort of split second situation. So we're going to talk about that. But, you know, the fact is that 13-year-old did what they asked him to do. They said, drop your weapon and put your hands up. He dropped his weapon, put his hands up, and he was still shot. We're going to talk about split second decisions that officers have to do. We can't hold officers to be perfect. And when they're not perfect, it doesn't mean that they have done something illegal, even when they're wrong. I'm not saying that the officer was right in this case, of having killed this 13-year-old. What I am saying is that it's worth us looking at, and it gives us an opportunity to discuss those situations where it's a split second decision and where qualified immunity, and that may very well. Right. Well, we hear everything that comes, and we don't know everything at this point. So I want to thank you for listening, or for listening, watching, being a part of the Valerie. No, this is Taking It Black. Just Taking It Black here on 987 KISS FM or KISS.com. And we'll be back next week, same time, same place. Thank you for listening. We'll see you next week. And the red. Thank you.
Okay, I couldn't see it.
Okay, we're going to end. Very good.